The Supreme Court today stayed an order of the Allahabad High Court which observed that quote-unquote grabbing the breasts and breaking the strings of a minor girl's pajamas did not constitute as rape or attempt to rape. The case pertains to an assault that took place on 10th November 2021. The three accused offered to drop the minor victim at her home by taking her on their motorcycle. Her father trusted their assurance and allowed the girl to go with them. On the way, the three accused stopped their bike and began sexually assaulting the girl. The prosecution charged that the accused grabbed the breast of an 11-year-old victim and one of them broke the string of her pajamas and tried to drag her beneath the culvert in UP's Kasganj. Now, due to the interference of the witnesses who heard the voice of the girl who was screaming, seeking help, the accused fled from the spot, left the victim behind. Now, on 17th of March this year, the Allahabad High Court ruled that such actions were quote-unquote insufficient to establish that the accused actually intended to commit rape, as they did not take any further steps in their attempt to rape the girl. The High Court also held that the prosecution must go beyond the stage of preparation to prove its charges against a rape accused. Now, a Supreme Court bench of Justice B.R. Gawai and Justice Augustine Gorge Masi have said that it was pained to see some observations in the verdict. They observed that the High Court ruling shows a total lack of sensitivity on the part of the author of the judgment. The Apex Court has observed that the decision was not made spontaneously and a verdict was delivered by the High Court 4 months after reserving the same. So, they had time for deliberation and to think it out before writing the same. I'm going to start my conversation. Joining me on the telecast is Ashwini Dubey. He is a senior advocate in the Supreme Court. Advocate Dubey, such travesty, the fact that the judge of the Allahabad High Court seems to be justifying his ruling, saying there was an attempt that was made to undress the girl against her will. The question arising, does this not amount to a rape attempt? And if it doesn't, then what does?
It is a mega, thank you for having me here. It is a serious matter and which shows the total insensitiveness on the part of Honorable High Court Judge. See, the Honorable High Court has jurisdiction to pass the orders or set aside, quash any judgment passed by any lower court subordinate to it. But the manner it was described, the manner it was narrated, that shows total insensitiveness. And Honorable Supreme Court very rightly, very often, and being the custodian of the Constitution and top court of the country, have rightly taken a suo motu decision. And Mega, I would like to tell your viewers and you, Murthal rape case, if you remember, the Murthal rape case was one of the example where the extreme situation appeared and none of the courts had taken cognizance at that point of time. But Honorable Supreme Court, being the top court of the country, even in the Murthal rape case, has taken the suo motu jurisdiction. Even Manipur, Honorable Supreme Court has taken the suo motu jurisdiction. And you see, one day before, that is on Monday, Napini ma'am is here, she would understand that one matter came up before one coordinate bench of the Justice Gawai, another bench of Honorable Supreme Court, and that was dismissed. Honorable Judge did not incline to issue notice, but the Honorable Supreme Court, exercising its jurisdiction, being the top court of the country, was with the jurisdictional power, constitutional power, have taken suo motu cognizance. And I hope, because what is happening, the violence against the women and that too against the children cannot be taken lightly. Here, it's not only the outraging the modesty of the women, but you are giving a clear-cut case, setting an example that if this kind of situation appears tomorrow, that would not amount to rape. Then why anybody would fear the law? Why anybody would hesitate in doing this kind of offense? So that is required. But yes,
okay. I'm going to come back to you. I have a question, and let me get in Miss N.S. Napinai, who's also an advocate at the Supreme Court. Thank you very much for joining me. And I would like to understand the technicality over here, because the top court says that verdict that was passed by the Allahabad High Court was quote unquote inhuman, was insensitive. Now,
Insensitive.
is this the question? Is it a question about the words that were used in the judgment that were quote unquote insensitive, or the very fact that the judge decided to pass a judgment saying that grabbing of breasts and breaking the pajama strings does not amount to rape attempt? Is there a clear-cut differentiation in the two?
Certainly, Megha, and I personally feel it would not be as banal as the first issue. I would think that the Supreme Court's observation is more deep, and it goes to the crux of the issue in terms of understanding where attempt starts, where preparation stops and attempt starts, and where it is stopped before its culmination into a criminal offense. NewsX, in fact, had covered this extensively, and I've already shared here earlier also. Kudos to you all for being there upfront on this. But if I were to just reiterate very briefly on what I had already shared, and that's where the insensitive observation comes into play, when you're dealing with issues pertaining to offenses against women and children, you're expected to take note of each fact and circumstance and understand the implication and apply the letter and spirit of law. So here, when you look at what a rape offense amounts to and where or how only a sexual assault would stop, to use words like it is only a minor offense and not the major offense at a preliminary stage where evidence has not yet been led and where circumstances exist to show that it is possibly a major offense is the issue that the Supreme Court, in my opinion, has highlighted. So when you talk about a rape case, as you rightly pointed out, it's critical for us to know when preparation stops, because the stage up to intention and preparation is not punishable, but attempt is punishable, right? So it's critical for you to know not just in terms of punishing attempt, but also in various other circumstances. I had briefly pointed out earlier also. Take, for example, your right of self-defense, which could extend probably even to causing death. At what stage can you exercise that? Can you exercise it at a stage of preparation? Certainly not. But could you exercise it at a stage of attempt? Certainly yes. And therefore, this delineation and what the Supreme Court will come up with going forward, and hopefully there'll be absolute clarity on this, and more importantly, lower courts will then implement that and ensure that it is captured in their handling of rape cases. That I think is critical.
Okay, I'm going to then ask you my next question, Advocate Napinai. According to the legal definition in section 376 of the Indian Penal Code, how is attempt to rape defined?
So attempt doesn't come under 376, it comes under 511. But the reasoning and the problem that if you see in terms of the High Court's order and why the stay probably has come up is, the issue that has always plagued rape cases is in terms of penetrative sex. Okay? After the Verma committee, that has also been done away with, diluted a bit in the sense that one particular clause has been included, such as manipulating somebody's body in order to commit, etc. Right? And now penetrative sex is not the only ground if you look at 376. Now when you talk about attempt, the issue then arises, are you trying to say that the threshold has to be penetrative sex up to a particular point? Do you really think law can work that way? Where it is supposed to lay down to what extent is it attempt and from where it becomes completion? It cannot be that way. No? So therefore, saying that the circumstances that have been set out in this particular case would amount to an attempt goes to the root of the issue in terms of rape cases, and that is why I already reiterated that it's critical that the Supreme Court lays down the ground rules clearly so that...
But do you think everything can be written down? Do you think everything can be written down? Shouldn't there be police probes?
That is precisely the point I
shouldn't there be police probes, and there needs to be interrogations and psychological tests of the criminals, of the rapists too?
Megha, that is where the sensitivity comment has come in. you will be sensitive to the facts of a case to interpret whether it is an Amma attempt or it is just a preparation.
Okay.
Where is that sensitivity in this case?
Okay, I also have with me Vikram Singh, former DGP, Uttar Pradesh. Vikram Singh, the Supreme Court has also pulled up the central government. It has also asked the Uttar Pradesh government to respond in this case. If a precedent such as this is set by a high court, how are we going to be able to tackle the innumerable cases of rapes and rape attempts and sexual abuse cases and sexual harassment cases that women across our country and children across our country have to face on a daily basis?
Valid question, Megha. Good evening, ladies and gentlemen. I would say that seldom have I seen such a travesty of justice as in this case. Thanks to Justice Gawai and Justice Masih, who have set a course correction. But what happened at the Honorable High Court was nothing short of an unmitigated disaster. You have the investigation. The investigators are there to see that they're professional, incisive, and come out with the facts, go behind the eyeballs of the perpetrators, and record what is possible to document and collect all evidence. The instructions given to the government and the police are that there are Nirbhaya guidelines and the recommendations of the Verma Commission also to sensitize the investigators and to have maximum number of women in such cases, sensitive cases at that. Well, if this level of miscarriage of justice can happen at the level of the High Court, I really don't know what could be a bigger travesty of justice than this to show what would be indicative of the fact what we would have expected, that the system of this country should have come down like a ton of bricks and ensured that justice is given to the survivor. Nothing like that happened. To the contrary.
But like I said, it took 4 months for the court. It reserved its verdict for up to 4 months. And then comes out with that statement, with that judgment. And here we are talking about, advocating about how there needs to be speedy justice, how there need to be fast track courts. So why did the court actually take 4 long months to actually come to a decision? Why? What do you think there was? What kind of an ambiguity were they at that point of time wrestling with to then come up with a decision such as this?
Megha, let me tell you that I have seen in another world. And during my time, I had met the Honorable Chief Justice and said such sensational cases should be put on fast track. And Justice Sodhi, I'll tell you, he was very kind and benevolent and ensured that the fast track court dispensed justice in record time. In this case, to sit over the judgment and deliver it after 4 months also is indicative of the perversion of the judgment initially given. Also, 4 months is not an ordinary time. The trauma in which the survivor had to go also speaks volumes about being indifferent to the human tragedy of which I am, when I say I, the system is privy to and indifferent to. Therefore, there's always a best way of doing everything. And to the contrary, what we have done is the worst possible way in which to handle a shoddy investigation, improper and imperfect prosecution, and the rest is history. But we could have done much better. And I do hope we draw on lessons and do not come up with such a disgraceful conduct in future.
I also have with me Deepika Narayan Bharadwaj. Deepika, this case was filed in 2021, came to court for hearing in 2021. This is 2025 now. More than 4 years have passed. And the Supreme Court has finally been able to take cognizance of this matter and stayed the Allahabad High Court judgment. The only question that perplexes me time and again is what sort of an ambiguity, what was the confusion or the doubt in the minds of the judges that it took them more than 4 years to actually pass judgment?
Megha, I would request you humbly to give me some time to talk. I concur with the sentiment of the panelists here, and I concur with the sentiment of the country over this judgment. The words used are definitely insensitive, and a High Court judge should have been more cautious about passing such order. But Megha, I want to bring out to you facts of the case. This is a case where the alleged victim is not 11 as reported, but the judgment quotes that the official records state her to be born in 2002, which makes her 19-year-old. Second thing, Megha, there was a molestation case filed by the relatives of the accused in this case against the relatives of the girl who is complainant in this case. So there was a molestation case filed earlier from the accused family side, and this case was filed later after that molestation case. So the
I'm
judgment
sorry, I'm
quotes
not privy
this
to
as
all
a
this
counter-
information. I'm
Megha,
not. This information is not out there on public record. So I don't know. Can I take your word for it? Is it your opinion? I do not know. What is clear cut? What is right now in front of the public domain, and the Supreme Court judgment, Supreme Court stay that has come on this order is as such, as I put out in my introduction, and I'm going to speak about this and discuss this and have a communication with all of you on the basis of the facts that are available with us, that are in public domain, that can be certified to be correct. Right now, what you say is something that I cannot verify. I cannot at this point of time find the truth in the statements that you are making. I'm going to come back to you, Ashwini Dubey, and let's hear it from you once again. And the question, as was rightly put up by Advocate Napinai, was the fact that the Allahabad High Court judge has spoken about him justifying the fact that he has called the attempt to called this act that was committed by these two men, these two rapists, these alleged rapists, criminals, was actually not an attempt to rape, and the point that he has actually taken help of is the difference between preparation and actual attempt to commit an offence. How does quote unquote greater degree of determination be determined?
Megha, let us what is in the public domain, as you rightly set out, without going to the facts of the case. There are facts of the case which Deepika is referring may be correct, or what decision comes tomorrow we would be discussing at a later stage. But what transpired from the judgment itself, the words quoted, Megha, were really objectionable. Point one. Point two, Napinai ji has very categorically said that Justice Verma committed a lot of efforts, this struggle, country this took, that in 2012 and 2013, that is only the new laws which were amended and brought in the criminal law with respect to the women were brought. Justice Verma Committee's recommendations were implemented, though finally, wholly it is not implemented as of now, but partially it is implemented. Sexual assault, attempted rape, if we see, and we see the jurisprudence of this, then of course, what is coming in the public, what is the statement of an 11-year-old girl, and if we take into account the POCSO Act, which is though is a gender neutral, not the women's centric. POCSO Act also says that if anything happens with respect to the sexual abuse or what with the child or below the 18 years age, then the POCSO Act shall also follow. So even if we leave aside these provisions of Indian Penal Code, Megha, then the POCSO Act comes to save that child. Maybe what would happen tomorrow, maybe personal enmity, what will transpire, I am not going to talk on the merits. But yes, the judgment is not in good taste, number one. Judgment gives the right, or why should we say right, that judgment gives an impression that those who will commit this kind of offense in the state of Uttar Pradesh, that will be cited as a precedent unless and only that part is set aside. Point number three, the trial court judgment must come in the evidences what has come, what Deepika is saying should also come in the public domain. But the judgment which has been passed by Allahabad High Court was not right, was very incorrect, was not based on the correct proposition of law, but not based what the women of this country are facing, because see, that was an attempt to rape and with a child of 11 years old. And if we start defining what is rape, what is not rape, what is attempt, and then we start describing the body parts of 11-year child, that is of course a question where the country stands with that girl. And what would happen tomorrow, Justice Gawai, okay, what the final order is passed, Megha, we would see, we would discuss. Yes, over to you.
Okay. Advocate Napinai, now the Supreme Court intervening in the matter, but we see a number of times there are cases and the courts come up with their judgments and they leave a bad taste in our mouths, because because of their insensitivity, because I don't know what has gone on during the proceedings, in the hearings inside the court of law. But do you think sometimes the criminals, the alleged rapists, end up benefiting by finding loopholes in the legal system?
Any accused would. Why only rapists? That's the whole issue in terms of advocacy. There is no harm in people using law within its parameters to protect themselves, be they victims or accused. The issue here is, what is a court expected to do? A court is supposed to be the arbiter which will decide in a balanced manner without moving into one extreme or the other. Deepika made a valid point. What happens if they are found to be innocent later? So be it. But that's not the issue today. Today you're at a preliminary stage. You're at which the court's order talks about, at a framing of charges stage. So evidence is not yet on record. Let evidence come on record. Let the accused prove themselves. That is the protection that the law extends to both the accused as well as the victims. But to decide something when evidence is not yet led, when there is not sufficient facts on record to decide something, but here it is not even about facts. Megha, it is about how the law has been applied. The law has been interpreted wrong and applied wrong. And at this stage or any stage, this kind of an interpretation of the law, given the facts that the judgment itself sets out, cannot be sustained. I think that's the crux of the issue. We are not really going into the facts. We are not a court of, trial to go into all that.
What
the law has been done incorrectly.
What penalty is the judge at the Allahabad High Court going to face for the judgment that he has passed few days ago?
Who is this question to?
For you.
Well, I am thankfully not in a position to have to decide that. I think that would have to be left to the superior courts to decide. We are already seeing a lot of flux in terms of how the high courts are being literally shaken up now. So let's wait and watch what is going to happen.
Okay, so do you think in essence there needs to be larger reforms that need to be brought into the judicial system?
See, I'm aware, and I have been part of training sessions now for 20 plus years, nearly 23 years or more. And I'm aware that the judicial academies take into account specifically sensitization processes for judges, particularly in terms of offences against women and children. And yet you do have a lot of these kind of cases coming out, and we have to keep in mind that these aberrations are not gender specific or space specific. It is not like this kind of a judgment has only come out of UP. You have a Bombay High Court judgment also which violated child rights. You've had a Madras High Court judgment also which violated child rights, etc. So these are just some examples I'm putting before you. The first is UP, you of course have this case. The Bombay High Court was the skin-to-skin judgment. The Madras High Court judgment where the Supreme Court intervened and reversed it was the child pornography case, where the court said we will no longer use the word child pornography, we will now say CSAM, right? So we are seeing this time and again. So I think it's not just about ensuring sensitization, but the academies may have to relook where things are going wrong and probably revisit the process in terms of the training or sensitization of both.
Okay. Vikram Singh, I'm going to come to you and seek a comment from you. What role can the executive play in ensuring that justice is given to the family, to the victim in cases such as this?
The executive and the administration have a role to perform, and I too have been a part of the training program and in increasing the sensitivity of the investigators in the department. But yes, in spite of having worked on the training and the sensitization of the force and the investigators, I think only very cosmetic changes have happened. I'm sorry to say that, but we have miles to go before we sleep. But yes, the investigation, the checklist, production of evidence using the best practices of forensics and also the medical sciences, and putting the evidence and also ensuring that wherever it's possible, test cases should be put up in fast-track courts and giving exemplary punishment in record time, not after 4 months or 5 months. And ensuring that if a case ends in acquittal, the number of acquittals that are happening is scary. I go against it that in spite of so many things that we are doing, the number of acquittals is scary, and even in gender cases. Therefore, every acquittal will have to go and address that. Has it been because of poor prosecution, poor investigation, or both? In that cases, there should be consequences for poor investigation or poor prosecution, or both, and see to it that if there is a case that falls because of any of these two infirmities, it should be brought to the notice of the higher-ups and appeal should be made.
Okay, all right. On that note, I'm out of time. I thank all of you for joining me on the telecast, and thanks for watching NewsX.